Good day. My name is Sirish Pandey, and I'm here to talk about Australian origin case. Actually, this case is between Australia and New Zealand Banking Group Limited versus Westpac Banking Corp. Well, this case is a typical example of money paid under a mistake of fact, and this is an Australian origin case, and this case was decided by High Court of Australia. Well, this case is a typical example of money paid under a mistake of fact, and it relates to unjust enrichment. Well, unjust enrichment is a legal concept referring to situation in which one person is enriched at the expense of another in circumstances which the law treats as unjust. Where an individual is unjustly enriched, the law imposes an obligation upon recipient to make restitution, subject to defenses such as change of position. Well, in summary, therefore, the word restitution means the relinquishment of a benefit or the return of money or other property obtained through an improper means to the person from whom the property was taken. Well, this also relates to contracts. Well, what contract is? Contract is uh, Contracts are a means by which parties create rights and obligations between themselves that are enforceable by the courts. Well, money was made according to this case. Talking about the issue, money paid under a mistake of fact was the general idea of this case. Here, ANZ Bank made a telegraphic transfer to Westpac Banking Group on behalf of a customer of Westpac Bank with a clerical error, and this clerical error was a sum of $100,000, which was more that was transferred. ANZ informed Westpac Banking Group after 3 days, uh, but ANZ realized it a bit late, so it informed it a bit late. In the meantime, Westpac had paid checks of his customer totaling to some $83,000. Unfortunately, the Westpac customer subsequently went into liquidation, and then eventually uh, 83,000 was already consumed by the customer, and the rest of the amount was due in its account of Westpac Banking Corporation. And the rules states that circumstances where restitution may be ordered are quite few, and some of them are there is a total failure of consideration, and another would be money was paid under a fundamental mistake of fact, and the third would be money is paid under a mistake of law, and the fourth would be money is paid under duress or compulsion. Well, applying the relevant rules according to application of the rules, here money was paid under a fundamental mistake of fact, and if ANZ had demanded the repayment of the overpayment, which is $100,000, immediately after the transfer, then Westpac would have been liable to pay that amount to ANZ Banking Group. But unfortunately, ANZ Bank realized it a bit late, and the money was already paid to the customer. It was actually simply a money paid under a fundamental mistake case, and the conclusion for this case would be that High Court held that since Westpac had received the transfer from ANZ as an agent or its intermediary for its customer, its liability to its customer was limitedly $17,000. Actually, the $100,000 from which $83,000 was already spent, and the rest would be $17,000. So this amount Westpac Banking Group is liable to pay to ANZ Well, talking about the rest of the fund, it has already issued a check to the customer, which has already been liquidated. So, unfortunately, the claim regarding that from ANZ would not be valid because it asked for the repayment after 3 days later, and the rest of the overpayment having already been paid out by Westpac on behalf of its customer. It received notice of the overpayment. So ANZ Bank would be getting $17,000 out of this case. Thank you and have a good day.